Mr. President, I come to the floor to respond to some of the debate on the Violence Against Women Act reauthorization, which I believe misstate the law and the content of the underlying bill, specifically as it relates to tribal court jurisdiction. First of all, I start from the premise that tribal courts should be able to prosecute domestic violence cases that occur on tribal lands involving tribal members. And the question is, under what procedure, what practice is it appropriate for them to attain jurisdiction over non-tribal members who commit these acts of domestic violence, who they wish to prosecute in tribal courts? I'm not here to question the integrity of the tribal court system for tribe members. The only question on the table is whether tribal courts, under the law that applies to these tribal courts, is required to protect the constitutional rights of non-tribe members who they seek to assert jurisdiction over. In order to protect constitutional rights, the Constitution as interpreted by the federal courts must be applied, and there must be an opportunity given to individuals who are prosecuted in these tribal courts who are not tribal members to appeal to a federal court if in fact they are convicted. Now, first of all, the distinguished senator from Washington, Senator Cantwell, has said that there is a right of removal to federal court in the underlying bill, and that is incorrect. There is no right of removal to federal court in the underlying bill. However, in the amendment which I have had contemplated offering, which the distinguished bill manager, the chairman of the Judiciary Committee, said is not acceptable to him, it would include a right of removal to federal court under some circumstances. So I want to correct the record. There is no right of removal in the underlying bill to federal court that might otherwise correct an unconstitutional provision. Under the tribal court legislation or tribal court jurisdiction, they operate under the Indian Civil Rights Act, which is by definition a statute and not the Constitution. So the rights provided to tribe members and non-tribe members under the Indian Civil Rights Act are not constitutional rights. They don't incorporate the Bill of Rights of the United States Constitution, which would be applicable to any American citizen tried in any state or federal court. And since Indian or tribal courts claim to be sovereign, and they don't incorporate those constitutional rights, then American citizens who are not tribal members who would be tried in those tribal courts under the underlying bill would be unconstitutionally deprived the protections of the Bill of Rights, which they have by virtue of the United States Constitution. Secondly, the distinguished senator from Connecticut, Mr. Blumenthal, argues that habeas corpus protections are sufficient to vindicate the constitutional rights of non-tribal members, but that's not the case. Habeas corpus is a remedy which cannot be accessed until direct appeals are exhausted by definition. And because that's the case, under the underlying bill, the maximum length of sentence that a individual can be given under the Leahy bill is 1 year. So what would happen is someone would be tried, an American citizen, non-tribe member would be tried in a tribal court, that they be wrongfully deprived of their constitutional rights under the Bill of Rights, but yet they could not vindicate those rights until such time as they exhausted all direct appeals, and then habeas corpus would be potentially available to them. The only problem with that is it's very unlikely that that would happen before they would have already served their sentence under the underlying bill, which is a maximum of 1 year. Thus, the habeas remedy is illusory and is not real. So, Mr. President, I hope that helps clarify some of the misunderstanding under the bill and my concerns about it. we start from the premise that domestic violence on tribal lands is a serious problem. And under the current situation, these crimes are not deemed sufficiently serious for U.S. attorneys to typically prosecute these cases. They are serious cases. They deserve to be prosecuted, but only consistently with the United States Constitution. And if the tribal courts wish to assert jurisdiction over non-tribe members, the only way they should be allowed to do so is if they incorporate the protections of the Bill of Rights. That is something I've proposed to the distinguished chairman of the Judiciary Committee, but which he has rejected. And we also have to have a means for an appeal to a federal court if a non-tribe member is convicted in a tribal court. That is not in the underlying bill.